Welcome. We are ready to begin the UAW FCA Ford General Motors Legal Services webinar, Fast Facts About 401k. Before we begin, I would like to tell you about an upcoming webinar we have planned. In February, we are planning a webinar concerning issues to be aware of when buying and selling real estate. Be on the lookout for additional information on this webinar in the coming weeks. If there is a topic that you are interested in for us to cover in a webinar, please let us know. Also, at the end of this webinar, there will be a short survey, and we ask that you complete it. Today, we will talk about 401ks. We have received a lot of your questions, and we hope to have answered many of them as possible. We will give you an overview of 401ks. Any questions about your particular 401k or investment should be directed to your plan advisors or your financial planner. We will begin with an introduction of ourselves. First, I would like to introduce Carrie Bernstein. Carolyn, or Carrie, as she is known to all of us, earned her law degree cum laude from the University of Wisconsin in 1990. She worked for the former UAW Legal Services Plan for almost 25 years, starting as a staff attorney at the plan's Flint office and eventually became a managing attorney. Today, she is a managing attorney at the new Plan Saginaw office. Carrie's public service extends into the wider community, where she has won several awards for contributing her time at the Legal Services of Eastern Michigan, helping low-income clients. Welcome, Carrie.
Thanks, Linda. And I'd like to introduce Linda Carr. Linda is a graduate of the University of Michigan, and she obtained her law degree from Wayne State University School of Law. And she worked as an estate and gift tax attorney for the IRS and later as a judicial attorney for a Wayne County Circuit Court judge before she joined the Legal Services Plan. Linda began her tenure with the former Legal Services Plan as a staff attorney and eventually was promoted to managing attorney. She practiced and trained other attorneys in the areas of bankruptcy, family law, tax, probate, and real estate. Linda is currently the managing attorney of the new plan's Dearborn, Michigan office, and she handles family law cases. Welcome, Linda.
Thank you, Carrie. Now let's get started. Fast facts about 401k. Carrie, can you tell me, what is a 401k?
A 401k is a way to save for your retirement. So as an employee, eligible employees have the right to put money aside, and they save and invest that money to be used when they retire, and the money is saved on a tax-deferred basis, which we'll talk about more in a little bit.
Okay. And how is a 401k established?
A 401k is established by your employers, who must operate the plan in accordance with a written document called the 401k plan document, and they also have to follow applicable laws and regulations for 401ks. The plan document will describe such items as who can participate in the plan. For example, maybe full-time employees, maybe part-time employees. The document will also discuss how much the employer will contribute to the plan, if anything. It'll discuss and lay out investment options for where you can put your money in, maybe a stock account, maybe a bond account, and it can designate whether or not you are allowed to take loans against your own personal 401k. So for more information about your specific 401k plan, you need to contact your own plan administrator, and they'll fill you in on all the details.
Okay. Well, Carrie, can you tell us how a 401k works?
First of all, employees have money withheld from their gross pay, and then that money gets deposited into their own individual 401k account. So each person has a separate 401k account. The funds are then invested however the employee dictates. So you get to look at those investment options, and you get to pick the ones that are best for you. You get a list of those options when you enroll in your 401k plan. Over time, the investments grow, and the employee gets to see how that money is growing, and then it's available to them when they retire.
Okay. And how much money is withheld from my pay?
Well, the good news is you get to decide that for yourself. So you
Very good.
decide how much you want deducted from your paycheck every week, and then that is the amount that gets deposited into your 401k. But there are some rules that apply. For example, there might be rules set up by your plan administrator. So talk to the financial institution about what kind of rules they might have in place. And then the IRS sets some rules as well. For each individual employee, they can contribute up to $19,000, and that's for the year 2019, unless you're over age 50. If you're over age 50, you can give an additional $6,000 a year, bringing you up to $25,000 a year. And that money grows tax-free until you retire.
Okay. Well, besides saving for retirement, contributing to a 401k provides other tax breaks. Is that correct?
That's right. There are several benefits to putting money in your 401k. First of all, when you put money in, the money that you save in your 401k is not subject to federal, state, or local income taxes. And the earnings grow tax-free until you start withdrawing the money at the time of your retirement. So you get a tax break now because your taxable income is actually reduced by the amount of money you put in your 401k. In addition, you benefit later because when you're working now, you're usually in a slightly higher tax bracket. You pay a higher percentage on your income taxes. And when you retire, you're likely to be in a lower tax bracket. So you get a double bonus by putting money in your 401k.
Okay. Can you give us an example of how that works?
So sure, let's compare if John contributes to a 401k with if John does not contribute to a 401k. So let's say John's gross income is $700 per week, and he does not contribute to a 401k. So every week he is taxed on the full $700 of income that he receives. But if he contributes to a 401k, let's say he still is getting a weekly income of $700 a week, but now he's setting aside $70 every week to put into his 401k. That leaves him with $630, and that's the amount that he's paying, or that is used to calculate his tax withholding now.
Okay, well, that is a savings. Now, can you tell me if I do have a 401k, when can I take my money out of my 401k?
That's a great question. So your age plays a very important role in answering that. There are times when you might be penalized. There are times when you're not penalized. And then there are going to be times when you absolutely must start taking distributions from your 401k. So the three critical age groups are if you're younger than age 59 and a half, if you have reached the age of 59 and a half and you're older than that, and then the last critical age is when you're 70 and a half.
Well, let's talk about each age group. What about those who are younger than 59 and a half? My first question is, why are our 401k rules different for those people who are younger than 59 and a half years old?
So the purpose of a 401k is to encourage you to save for retirement. They don't want you to tap into the money too young because then you won't have anything left over when it's time for you to retire. So to encourage you to keep your money in that account until you retire, there's a penalty that's imposed if you take money out before you reach age 59 and a half. That penalty is 10%, and it's in addition to the income taxes that you have to pay on the amount that you take out early.
Okay. Well, can you explain to us, Carrie, how that works?
Sure. So say you've decided you want to take $5,000 out of your 401k account, but you have not reached the age of 59 and a half yet. So $5,000, 10% of that is $500. That's the penalty that you have to pay. But the applicable federal, state, and local income taxes, they're going to be calculated on the entire $5,000. So it is a double hit.
Well, are there any exceptions to these rules?
Well, there are some reasons why you may be able to withdraw money earlier than that, but every plan is a little bit different, so you'll need to talk to your bank or financial institution that administers your 401k. But sometimes there are exceptions if you're over age 55 and perhaps you lost your job or you've become totally disabled. But beware, that is usually set up as a one-time opportunity, and you have to take it in the year that the event occurs, like the year that you become disabled or you lose your job.
Okay, now let's go on to the next age group, those who are 59 and a half years old or older. How is this group treated differently than the first group?
Once you reach age 59 and a half, the IRS figures that you're close to retirement, or maybe you've already retired, and so the rules allow you to start making withdrawals from your 401k, but you don't have to take them if you don't want to. So it's a good idea if you can let the money sit there as long as possible, because remember, it grows income tax free.
Well, what happens when someone takes money out of the account at this time?
When they're 59 and a half?
Yes.
Well, normally what happens is your financial institution that administers the 401k will take about 20% off the top of your distribution, and they'll hold it back for taxes. But your actual taxes might be different from that, and you should consult with your own personal tax advisor about how to pay income taxes on it. Every year, when you make withdrawals from your 401k, you'll get a 1099-R form from your account custodian, and that'll tell you exactly how much you got in taxable distributions that you have to report on your income tax return for that year.
Okay. Now let's say I decide to take money out at this time. How much money should I take?
Once again, that's completely up to you. You have full control over your own 401k account, and when you reach age 59 and a half, you can take as much or as little as you want at that point. But there are a number of factors that you really should consider. You might want to look at the amount of money that you have saved for retirement. Think about whether you have other sources of income available to you, like Social Security, or maybe you have other pension or retirement funds. And then you also want to consider how long you want your 401k to last, because if you're from a long-lived family, you might need to stretch that money out for many years after you retire. So the thing to do might be to talk to your financial advisor about the best way to plan on spending your 401k.
Okay, thank you. Okay, let's talk about the last group, those who are older than 70 and a half years old. I noticed the slide says something about required minimum distributions, RMD. What does that mean?
If you're lucky enough where you didn't have to tap into your 401k until you reach 70 and a half, now the IRS says you've got to start taking deductions or withdrawals from your 401k. And the reason is because, that money has been sitting there tax-free for all those years, but at some point, the IRS wants to begin charging income taxes on it. So at 70 and a half, there are rules for how much you're required to take out every year. That's called your required minimum distribution, or your RMD.
Okay.
So that amount is calculated based on the account balance at the end of the previous year in your 401k, and the IRS then determines how much you have to take out based on your life expectancy, as determined by the IRS's mortality tables. So your life expectancy changes all the time. And they'll calculate it out based on what your situation is at the time. So for example, if you reach 70 and a half in August of 2018, for 2018, you've got to make your RMD, your required minimum distribution from your 401k, no later than April 1st by 2019. They give you a few extra months that first year. After that, though, your 401k withdrawals have to be done no later than December 31st every year. So you have to take your RMD for an entire year, no later than that.
Okay, well, suppose I don't want to take my RMD.
Well, if you don't want to take your RMD, you're going to get hit with a stiff penalty. The IRS wants to tax that money. They will hit you with a 50% penalty on the amount that you fail to withdraw if you don't take it out by the deadline. So it's really important. We suggest you work with your plan administrator they'll help you calculate how much you're supposed to take out every year. And usually you can set it up so that it happens automatically as well, so you don't miss any of those important deadlines.
Okay. All right, let's turn to a question that many of our viewers have asked. Can creditors get money out of your 401k?
The good news is that your 401k funds are generally not subject to garnishment by private creditors. So even if a creditor sues you and gets a judgment against you, maybe for something like a credit card debt or a personal loan or even medical bills, those creditors are not permitted by federal law from tapping into your 401k account.
Very good.
However, once you start taking money out of your account, if you deposit it in a regular checking or savings account, then the creditor with a judgment against you normally can garnish the money from your checking or savings. Some states, though, have special protections as long as your 401k withdrawals can be traced back to the 401k. The money might be protected for a little while, even when you put it in checking or savings. But if you want to know what the rules are for your particular state, you can call the legal services plan. They can fill you in on the law in your state.
Okay. Well, Carrie, are there any instances or circumstances in which my 401 funds can be reached by other parties?
There are a couple circumstances where the money can be taken out, maybe even if you don't want it to be taken out. So the funds in your 401k are subject to division if you're divorced, and if a quadro, a qualified domestic relations order, is entered by the divorce judge, that might very well require that your account be split. And so they have to do it for that reason. Another reason is if you owe the federal government back taxes, then yes, the federal government can dip into your 401k to recover what you owe them.
Okay. Now, we've also had several viewers also wonder what happened to their 401ks in the event of a divorce.
In the event of a divorce, the rules change depending on where you live and even locally. So the best thing to do is probably contact the legal services plan for advice about your specific case. But there are generally some factors that may influence negotiations over a divorce settlement. Things like how long you've been married, things like what your total assets are, what your spouse's total assets are. Also, they might look at whether your spouse has his or her own 401k or pension plan set up. And they'll also perhaps consider things like your ability to work, your spouse's ability to work, or any other health issues or disability concerns. So remember, call the legal services plan and we can give you more information about how it might work out in your individual case.
Okay. Now, we've also had additional questions from our viewers as to what happens to my 401k if I file bankruptcy.
The good news is that if you have to file bankruptcy, either a Chapter 7 bankruptcy or a Chapter 13 bankruptcy, which is for if you're going to make payments to your creditors over time, your 401k is not considered an asset that you have to give up. It's protected. So you get to keep it in the account and it continues to grow while you're in bankruptcy. But if you have an outstanding loan against your own 401k account, that loan is not dischargeable in bankruptcy, meaning if you don't continue to pay it, you're going to be faced with those penalties and the tax consequences of that. So you still should arrange to repay the loan. And if you are repaying the loan and you're in a Chapter 13 bankruptcy, making payments over time, the loan amount that you are repaying every month is not counted as disposable income. So you end up paying less to your creditors. Okay. Now, if you have filed for a Chapter 13 bankruptcy and you've been making contributions to your 401k, not just loan repayments, those contributions are probably going to have to stop. But if you want to know more about that, then you should discuss that with your bankruptcy attorney.
Okay, Carrie. Let's move on to a different area, beneficiaries. Some people do not really think about naming a beneficiary on their 401k account. But there are a few things people should know about this. Let's start out by explaining who is a beneficiary and how you can designate a beneficiary for your 401k.
Well, I believe that naming a beneficiary on your 401k account is one of the most important things you can do. And it's just a really important step that you should take, especially when you're setting it up. So a beneficiary is the person, or perhaps multiple people, who are going to be entitled to receive the funds in your 401k when you die. So if you want more than one person to share, you would list multiple people, and you can list them by percentage, and then they will get that money automatically when you die by filling out a claim form after your death. So the important thing to know is that the beneficiary form controls, and that's true even if you have a will that says something different. So if you have a will and you're leaving everything in your will to your kids, but you've got a 401k where you've named your sister is going to end up with your 401k money, and it'll be hers to do with as she chooses.
Okay. Well, Carrie, suppose I have a 401k and I've named the beneficiary, but at this point I can't remember who is my beneficiary. What do we do?
I don't think that's very unusual. I think people often forget who their beneficiaries are. And it is a good idea to check this information periodically by contacting your plan administrator, the bank or the financial institution that's managing your money. In particular, there are times when you really need to change and update your beneficiaries. For example, if you were recently divorced, or if you've been married recently, if your beneficiary died, you're going to want to update your beneficiaries. Also, if you've recently set up an estate plan, perhaps you've had a will done or a trust, you're going to want to make sure that your beneficiary designations are consistent with that estate plan that you've set up. And there may be other reasons why you're thinking of changing your beneficiaries, so you can always call the plan and we can help walk you through those things.
Okay. Well, Carrie, who do I name as my beneficiary? Are there special rules for a 401k?
There are some special rules that you need to be aware of. If you are married, the law states that your spouse is automatically your beneficiary of your 401k. But even though the law says that, we strongly encourage you to fill out the paperwork to make that happen. Your plan administrator can provide you with the beneficiary form to fill out, but we definitely think you should not rely just on the law, but fill out the beneficiary form. So sometimes you want your money to go to somebody besides your spouse. You can only do that if your spouse agrees to sign a waiver form, which is part of that beneficiary form you can get from your plan administrator. It's also important if you're married and you know your spouse is going to receive your 401k if you die first, that your spouse understand, where the 401k is held, and they're going to be given a couple different options on how to collect that money at your death. So one option might be they could cash the money out. So if they cash out your 401k, if there's a lot of money in that 401k, that's going to be a lot of taxable income to your surviving spouse in 1 year. And that could be enough to bump them into a higher tax bracket. So that might not be the best option for them. Another option your spouse is going to have is to roll over the money into a new IRA in your spouse's name. And if they roll over the money that way, then they don't have to cash it out, and it's not a taxable event at that time. Now your spouse can follow the IRS rules, and if they don't want to start taking money right away, they don't have to. They can wait till they're 70 and a half to start taking money out, and they can stretch those payments over their life expectancy, and that's going to provide them with some tax savings over time. So we really encourage you to make sure you talk to your spouse about it and make sure to get that beneficiary form filled out.
Okay, Carrie, now I've set up my 401k. My spouse's name is the beneficiary, but we get a divorce. What happens now?
This is another one of those times when you really need to change your beneficiary form. You need to change it after your judgment of divorce is finalized and entered by the court. And that's true even if your spouse has agreed to give up all rights to your 401k in the judgment of divorce. You can't rely on the judgment of divorce saying one thing when your beneficiary form says something else. because it can definitely result in possible litigation, with the court having to get involved before people can collect their money. So as soon as your divorce judgment is final, you need to get a new beneficiary form from your 401k plan administrator and update it. Or call the legal services plan if you want more information on how we can help you do that.
Okay, so at this time, I have a 401k, I've gotten divorced, and now I decide to remarry. What happens now with my 401k?
I'm sounding like a broken record, but it's important to update your beneficiary again. Once again, if you are married, you want to do the new beneficiary form after the date of your marriage. That way, it'll be very clear who your beneficiary is going to be. Remember that your spouse becomes the new beneficiary automatically, but again, if your document says something else at the plan administrator's office, you run the risk of there being confusion and possible litigation necessary to sort it out. This is especially true if maybe you left your old spouse on there, or maybe you have your kids on there. So do get the beneficiary form and update it. Now, this is true even if you and your spouse sign a prenuptial agreement where your spouse promises to make no claim for your 401k in the event of a divorce. That agreement is one thing, but then it has to be carried out. So after the date of your marriage, your spouse needs to sign that waiver form, and you need to sign a new beneficiary form designating beneficiaries of your choice. Again, it's a good time to talk these things over with the legal services plan who can help with your estate planning.
Okay, continuing our topic of beneficiaries, we have some viewers who wanted to know if they could name their children as beneficiaries of their 401k accounts.
You can, assuming that either you're not married or that your spouse agrees to that and signs that waiver form we just talked about. And there's really no problem if your kids are adults and if they're not disabled, because you can name all of your kids as beneficiaries and you can designate percentages, and then they can get and control their own share of the money. They can do whatever they want with their own share. What you don't want to do, though, is name one of your kids with the understanding that that child is going to split it up between other kids, because legally that is not what happens. The money pays to the person you name, and they get to keep and do what they want with their own share. So if you want to name multiple people, you have to fill out the form to do that. Now, also consider that if you have minor kids, it's a more complex situation, because your plan administrator is not going to want to pay your 401k money to a minor child. They're going to want to pay it to somebody who has legal responsibility to manage the money for the child. If you have an opportunity to set up your own estate plan, you get to designate who you want that money manager to be. It could be the trustee of a trust set up for your minor children. But if you don't do it and there's no beneficiary, or your kids are minors and you're expected to get the money at your death, then a court might have to get involved, and a court might decide who should be the one managing the money. And if the court is controlling it, they might pick somebody you would prefer not to have them control.
Okay. Now, we also have some participants who say, I'm single, I'm not married. Are there any restrictions on who I can name as a beneficiary to my 401k account?
None whatsoever. You can name any individuals you want. They don't have to be family members. They can be friends, whoever you want. But again, you're going to want to designate everybody you expect to get a share. You're not going to want to leave it up to one person named as the beneficiary to turn around and split the money with other people. And there are tax reasons why that's a bad idea. If the person who's your beneficiary decides to withdraw the funds, the good news is, no matter their age, they don't have to pay that 10% penalty. But they are going to have to pay income tax on the amount that they take out. If they want to, though, they can choose to roll over the money into an inherited IRA, and then they can stretch out the payments over time, and that'll save them a lot of money by keeping their taxable income lower every month.
Okay. Now, finally, we have someone who asks, should I list my estate as my beneficiary to my 401k account?
Well, we talked about the tax advantages of naming individuals as beneficiaries of your account. And the reason why is because they can roll over the money and stretch out the payments over their life expectancy to reduce income taxes. But if you don't name anybody as a beneficiary, or if your estate is the beneficiary, then the money has to go through probate generally, and there are going to be some expenses for that. And in addition, the only option is going to be to cash out the money, and that's going to boost up the income taxes owed in the 1 year and rob your family of the chance to spread it out over time.
Okay, now we've had some very interesting questions from our participant. And we had one who said that she had been married for 43 years and she had been separated for 3, but not legally. She wants to know if she's still entitled to half of her husband's 401k account, even though she is still working.
So if there's no legal divorce, there's no mechanism for getting a split of your husband's 401k. You can't just take half of your husband's 401k. But there are some other interesting issues raised by this question. So as long as you're married, keep in mind that you are automatically the beneficiary of your husband's 401k account. So if he died, you would get that money, even if you've been separated, unless you signed a waiver allowing him to name somebody else as your beneficiary. But also keep in mind that if you have a 401k, then your spouse is automatically considered your beneficiary as well, unless you've gotten a waiver from him. So if you want more information, ask the legal services plan and we can talk to you about your situation.
Okay. We have another participant who's about 66 years old and he's ready to retire. He wants to know if there's a penalty on his Social Security if he spends any of his 401k after his retirement in April 2019.
So that's a good question. There is a difference, though, between wages and taxable income. Okay, so your 401k withdrawals are not wages. So taking money out of your 401k results in you having to pay income taxes on that money, but it's not going to affect the amount of Social Security that you get. So you can take as much or as little as you want and your Social Security stays the same.
Okay. Now suppose I'm working 2 jobs and I have 2 different 401k accounts. Can I roll over funds between accounts? Both have different plans, have different investments.
Okay. So you're saying you have different investment options with more than one 401k. Yes. So whenever you have more than one 401k, remember that it's the 401k plan document that is in charge of administering each of those plans. So you would need to address those questions, what you can do, whether you can roll them over or merge them. You have to address those questions to your plan administrator. They're the only ones that can answer that for you.
Okay. What kind of information do I need to give to my spouse to keep on hand about my 401k if he needs to use that or if he needs to know what's going on with my 401k?
Okay. I think you should definitely make a record of where your 401k is being held, what bank, what financial institution, and you should also make note of the account number so your spouse has that information to make a claim in the event that you die. But if you need help accessing the money while you're living, then that might be something you should talk to the legal services plan about, because it's possible for us to help you with a power of attorney. You could give your spouse authority to access that money during your lifetime.
Okay. Can someone have more than one 401k account? And how much can they defer on their taxes each year?
Yes, it is possible to have more than one 401k. You might have 2 different jobs and have 401ks with each of them. But the rule is that you can only have a combined $19,000 under the IRS rules that you can contribute every year. So you have to keep close track of what your contributions are and not go over that unless you're over age 50, in which case you have that extra $6,000 annually that you can contribute up to $25,000. And you should be aware that you have an opportunity, if you want to, I lost my train of thought. Sorry about that.
Okay. we have an opportunity to withdraw, but you cannot put more than $19,000.
Oh, I know, I was going to say that
those
every
accounts.
year those amounts change a little bit.
Okay.
So it may be that this year it's $19,000, next year it might be a little bit more than that.
Okay. Now, so we want to start withdrawing from our 401k account. Will these funds be taxed at the payroll rate or as at the capital gains rate?
Well, when you start withdrawing the money, it is going to be taxed as taxable income to you, not at the capital gains rate. So again, you might want to talk to a financial advisor about how to set that up and how to think about that.
Okay. Now, we've talked a lot earlier today about beneficiaries and having your spouse as the beneficiary, but she does have an opportunity to waive it, okay? So we have a question that if you have a waiver from your spouse to give partial amounts to other individuals, such as your children, okay, if you wanted to change that allocation, is it necessary for that person to do a new waiver or to obtain a new waiver from the spouse?
I think that you should discuss that information with the plan advisor, but we would recommend that you get a waiver every single time, because if you're naming somebody other than a spouse, then if the document doesn't have that waiver filled out, they're not going to go back and look at old beneficiary forms. So I would strongly recommend you get a waiver on every single beneficiary designation that you make.
Okay, at this time, we would like to thank you for your participation today and to remind you to complete that short survey, which will follow after the end of this webinar. If you have a legal matter, please contact your UAW FCA Ford General Motors Legal Services Plan at 800-482-7700. Thank you.